customers they have. As I suggested, there could be a chipset manufacturer, there could be network player, and there could be only simply assembler, a manufacturer who assembles the handset and sell in the market. They are not technically equipped to ascertain the essentiality or the validity. They simply import or purchase the chipset. As the case in India, the multiple players, what they do, most of them, they import the chipset from China, they assemble their chipset and sell under their brand name. They do not have the infrastructure to ascertain either the validity or the essentiality. They look upon either the chipset manufacturer or on the innovator company for the guidance whether this chipset has the patent which are essential to certain technology, whether I am purchasing a chipset which has multiple essential patents in it or not. In that context, considering the market scenario, and therefore this particular segment is unlike what Deepak suggested, an open market where you can go and bargain, where the customer and the bargainer both are knowledgeable enough to bargain a price. Here probably a particular kind of implementer may not be in a bargaining position because they couldn't understand what are going into this manufacture of this chipset, how many patents, what should be the proper value. And in that context, the onus lie heavily upon the innovator company, on the standard setting organization, and probably then the court, if the innovators are going to the courts and asking injunction based upon that, I am very much sure court will be justified, and to my mind, courts will be justified in granting ex parte injunction. In that context, these are early days in India. The courts have given a good guidelines by way of the interim injunctions, by way of the settling arrangement between the parties of the interim royalty. But in the coming days, court may be looking at the patentee and the innovators, what were your bona fide? Like you said, there should be consistent approach, consistent global approach. But now, since we have seen many precedents either in US or in the EP or in India, why not the innovators company should also look at those precedents? They should, and the standard setting organization, they are not moving forward. They should also incorporate certain factors. They suggest something so that it will help ultimately for the grant or non-grant of injunction. Injunction may not be ultimate remedy in a case of in a commercial case. It is a rule that if ultimately you are suffering some kind of loss of profit or gain of profit to somebody, you can be compensated at the end of the day by a reasonable damages or reasonable loss of profit or reasonable gain of profit to the implementer. In that context, if the tone is well set by the standard setting organization, by the innovator companies, probable ascertainment of the FRAND terms in cases of the essential patents may not be that complex. It will also lead to a good injunction, and good injunction in the sense that it will be easier for the implementer to also ascertain they are actually compelling themselves to a situation where the court will be granting injunction against them, and they will be in a better position to estimate beforehand whether they will have injunction against them or not. Having said that, to my understanding, in the current scenario, the injunctions in India is the need of the hour, where there are multiple implementers. As Deepak and the CITL are suggesting, they are not coming forth, but to my understanding, court so far has looked into the facts. They have appreciated this particular approach that the innovator companies have done a good job in reaching out to the implementers, but implementers has not done their part well. And in that context, the grant of injunctions, to my mind, is justified. And so far, in Indian context, it is a good remedy to have as interim injunction. Thank you, Patrick.
Thanks, Sanjeev. I would like to get some quick comments from Sheetal and Deepak, but before I do, to counterbalance that, because I think it's interesting to look at the dichotomy that exists between the injunctions that are, the state of injunctions in each of these three regions of the world. Asia, India versus Europe and US. And so I would like to just ask Stefan to, if you could, compare and contrast against what Deepak was, I'm sorry, Sanjeev was just describing.
Yeah. I think we have, after the ECJ ruling, in so many words, the rule that if you have an unwilling licensee, an injunction is to be granted. The problem we are now facing with is determining by the courts what is an unwilling licensee. That's a process that's ongoing. I don't know whether you can resolve it by the court. A second issue that was addressed by Sanjeev was how to determine essentiality. There's a tendency in the courts to say, okay, well, that's what we always do. It's an establishing essentiality is an infringement issue. Bring it before us, we assess it. So ultimately, you can bring the case to court. The court will say, okay, this is essential. When you use a standard, you automatically infringe or not. Whether this is a feasible thing, I don't venture to say. Personally, I believe this is something that should be done outside the court. It should be done out of litigation, but actually I have little clue how to accomplish that. We have, I may mention this, one idea we are discussing in Germany is some kind of instituted non-binding arbitration. We have this with employees' inventions, where you have, according to German law, pay remuneration. And basically, it's a panel set up by the state, by the government, and it's compulsory to arbitrate. Every party can accept the arbitration result or not. They can go to court. What happened over 40 years was that the panel did such a good job that parties rarely go to court. On the other hand, if you have an established panel that makes reasonable recommendations, it's of course for a party more difficult to go to court and to present itself that it's the reasonable party. One point I would like to contradict, Patrick, it's not only the reverse hold-up that's an issue, it's also the hold-up, and I'm talking about patent trolls. We have one non-practicing entity in Germany that simply bought a huge portfolio of telecom patents from a German company that ceased the business, and now they're really vigorously enforcing, and basically here the market, the ecosystem of the market does not work because this company is out of the market. They just want to squeeze out as much money as they can, and in fact it's the innovators that are fighting this company to get to a reasonable resolution.
Yeah, thank you for that, Stefan. And we can come back to that if we have any time, but I want to give Sheetal a chance to respond to Sanjeev's comments and to what Stefan was saying. And then also, if you could, briefly, because we're going to run out of time here, just good or bad, the role of government groups like CCI and others in this whole process. Is it helpful or a hindrance? But I'll give you a chance first to respond to the initial issue on injunction.
First of all, before I really get into my response, Sanjeev is a good friend. That's a disclaimer.
Was a good friend. Was a good friend.
He is definitely a good friend, and I really appreciate his viewpoint that transparency needs to increase. While there is a lot of declaration, but no one knows how many are actually essential, and he wants SDO to do that job. With again a same disclaimer, you remain to be a good friend, but I think you are trying to say that a chemist should do a job of a doctor as well. Not only he should discover the drugs, but he should actually go inside the hospital and start doing a surgery. I think there are people who are meant to do their specific tasks, and let them do that first. SDOs, if you look at the preamble, their main job is only to come up with the technological developments. Come up with the best of the technology, ask companies to do the R&D, and find the best solution that all of us as a consumer are happy to have. Whether it comes, who will define essentiality, whose job is it, I think it's a job, number one, of an innovator, as you rightly said. And innovator is doing the job. I don't know whether you got a chance to really sit through the negotiation table. I have sat through at least two. while the unwilling licensees continues to say, get me this document, get me that document, patentee always shows a complete claim chart. And we rarely say that while at SDO you'll find hundreds of patents being declared as essential, but when I show you claims chart, this is the essentiality. He proves right on the day one when he goes out to seek a license. It's never the other party who came to me. I'm the first one who has proved, number one. Second is, I don't know from where you got the picture that implementers are naive enough, they are so innocent, they may not know the essentiality, but they are the ones who are hiring best of the lawyers to let them know what patentee is saying is actually truth or not. Third, if there is still a dispute, let courts decide, and courts have decided, right? Okay. Now that's the only response to your question, Sanjeev. You asked Patrick about why injunctions are important. Injunctions are especially important, at least in the case of an essential patent. And the reason Deepak already said that there is no downside for the implementer to anyway come forward and ask me a license. Why? If you look at the SDO's website, anyone, I don't know who is an engineer in this room. Anyone here an engineer? I am not. But you are an engineer. An engineer would know the codes decoding if you have done engineering in the telecommunication side. If you go to a SDO website, you'll find tens and thousands of such codes freely available to any engineer, and he can really create a chip or maybe send it as a contract and set up his own business. He doesn't have any incentive to come really to me as an innovator and ask a license, because the entire technology transfer is available up on the SDO's website right on the day one. Then what is the incentive, at least what is the stick on him to at least come forward and seek a license? Injunction. And I think that's the rightful way, or a legal emanation given at least to a patentee who is like pleading with folded hands to please come forward and seek a license. Injunctions becomes absolutely important in that case, especially when we talk about ICT area, and I'll just close. And I really wanted to say many things because he has touched the nerve in me, which pains me a lot. But the last word, ICT is a technological area which we are handling, which has a very low shelf life. Today you have this phone, tomorrow you'll have some other phone. We were in 2G back in 1980. The moment we reached in 1990, we had 3G, and now we are talking about 4G and whatnot, 5G as well. So if you continue to not give injunction as the only remedy which is available to an essential patent owner, dare I say, we'll be back to the Stone Age where we were back in 1980, where it used to take 10 years to get a phone connection, as against where we have reached today. You are just filing up the paper and your chip is up and active. That's it.
Thanks, Sheetal. And I'm going to ask Deepak for a 2-minute summary, or if you have a last comment, because we're going to close our panel so that we can go to lunch. So remember, lunch is next. You may have
Thank you very much.
The forces will descend upon you if you are not quick.
If lunch is next, then my only summary comment is thank you. Anyway, few things which generally comes to my mind is the ignorance of a party cannot be taken as a plea. So I understand that the implementers are not technologically aware of the fact, and I highly appreciate that. But given that the resources to evaluate whether the technology is essential, whether the patent is essential, not essential, they do not have to be in-house aware of it. All that I'm saying is that way. Let them go and get the resources. Appropriate resources are available outside. Maybe that will be the best opportunity for them. And as far as the injunctions are concerned, as I started when the discussion, there could be instances where the bona fide of the implementer could be much better off. The cases which, fortunately, if you look at the ZTE versus the European case which got litigated between the two Chinese companies in Europe, that was only onto the issue of whether there is a proof of willingness, whether the willingness is being proved by the defendant or not. So there would be instances where something of that extent would come up in the